All right, folks, we're going to get started. Thank you so much for choosing this session over drinking for the rest of the afternoon. We do know that the only thing that stands between you and free cocktails is us. So we are going to do our best to both entertain you and get you out of here on time. By the way, I can't see any of you because I'm literally blinded by the light. So, so if you want this to be interactive and you have questions, I would say raise your hand. But no, just stand up and start shouting at me. Welcome again. Let me just introduce our panel here. First of all, there's one handsome individual right there. As many of you know in this room, I'm John SABLONE. I chair, you know me in my capacity as chair of Nixon Peabody's Private Fund Dispute Group, which is where we typically interact with the offshore world. There's another hat that I wear, which many of you don't know, and I also chair Nixon's Electronic Discovery and Digital Evidence Group. And so that's why this particular panel, called Big Data, Big Headaches, sort of merges my two passions. So I'm really excited to be here and to talk with you about these issues and sort of lay the groundwork of what we're doing in the US, what's happening in other jurisdictions with respect to electronic data discovery. So that's going to be a fun and new program for me, for this crowd. To my immediate left is Brian Kelly. You can read Brian's bio up there on the screen, but Brian spent 25 years as a federal prosecutor in both Boston and San Diego. Brian's claim to fame, for those of you who don't know, is that this man right here, is the individual who prosecuted the infamous gangster Whitey Bulger, and did a fantastic job of it. For those of you who saw the movie, Brian was not in it.
He was supposed to be.
Allegedly, he had a cameo, but they cut it. I'm waiting for that director's cut still to see if that footage appears. So, and Brian's going to talk with us a little bit about the criminal and regulatory aspects of the U.S.'s reach, both offshore and then offshore coming onshore, in terms of data and how some of the federal agencies and government actually go after individuals, what types of information they look for, how they actually get people into the U.S. and prosecute them. So he's going to handle our sort of criminal and regulatory side. And then next to Brian is my partner, Matthew McLaughlin. Some of you in this room do know Matt. We work together on a lot of matters. Matt is a partner at our firm. He's also served as a special assistant district attorney in Massachusetts. However, Matt's going to talk today about a little more of the civil side when we start thinking about data production and ways to get data in the U.S. and ways that offshore funds and corporations can use the U.S. as a discovery center. Matt's going to talk a little bit about those ways and how the U.S. can assist offshore with some of those needs. So without further ado, we're going to get started. And I keep turning away from you because I am blinded, so just bear with me. We're going to talk a little bit about e-discovery in the United States, and you may have seen in the teaser, we talked a little bit about this UK decision, which we're going to get into, and then obviously we'll have questions. Again, folks, feel free to jump in with questions along the way. This is interactive, and at some point when I read the crowd itching to go drink, I'm just going to cut it short, so don't wait till the end. I want to just put up a few slides about what electronic discovery is. Many of you in this room may know, but some may not. When we just think about the explosive growth in global data, going back to 2006, and remember that's now a decade ago, there was 191 exabytes, which is 191 billion gigabytes of digital information that was created, captured, and replicated. And it's increased tenfold since then, and it's only increasing. 75 billion email messages sent every day, and 100 million text messages every day. And these are old stats. This is not even current. My little humor here, this is what we lawyers like to think of. We've got our database of useful information, and then of course everything else, which nobody cares about. And the trick that we had to learn over the last decade or so in the US, and that I think other jurisdictions are beginning to fall into, is how do we segregate what's useful from what's not useful? And how do we look at all those exabytes and terabytes and petabytes of information and get what we really want and need? And that's what we're going to talk about today. Just to give you a sense of the volume, what a megabyte is, a gigabyte, and a terabyte. So a megabyte, which we think of as not very much, is essentially a short novel. The important thing here is I like to look at a gigabyte, which is about 100,000 emails. And 100,000 emails in the old days, we would say it's about 65 boxes of documents. When you talk to most US lawyers, especially associates who do a lot of this work, they will say things like, oh, it's a really small case, it's only 10 gigabytes. Well, think about that for a minute. 10 gigabytes would be 1 million emails and 650 boxes of documents. We used to not consider that a small case. We used to consider that a very large case. So something to keep in mind. And then we start talking about terabytes, which we do. Most cases now we measure in terabytes in terms of the data that we look to. It's pretty typical in a normal commercial size litigation to think you start with a terabyte or two of data. And a terabyte is 1,000 gigabytes. So it's 100,000, it's basically 65,000 boxes of paper, to look at it that way. Where do we find data? We find it all over. It's places you'd expect it to be, and then it's in all kinds of new places today. The places you expect it are in databases and presentations and webmail and all the rest, but more and more it's in apps, it's in conference tools, it's on social media, it's in voicemails. You know, every time, I'm sure most of you have this, every time I get a voicemail, what do you get? You get an email that's sent to your corporate server with a WAV file that has the voicemail, and sometimes even a rough transcription of that. So we found ways to even take things that were not data-driven and turn them into data. And so more and more that's filling the coffers of our corporate servers. Also, some newer examples, cloud computing, we can talk about that later if you want, software as a service. Essentially, the entire mix of information that's now coming out of hard drives and storage that you can hold and touch and going up into the cloud. And as it gets into the cloud, we run into all kinds of jurisdictional issues. And we'll talk about those a little bit later, because when you think about it, and we've had these problems pop up, if you have your company's data in the so-called cloud, well, the cloud is a nice euphemism, but the reality is that data sits somewhere. It's not really in the cloud. It's actually on a server in some country. And many times that country might be Singapore, it might be China, it might be France, it might be Germany, it might be Brazil, it might be the United States. And when you have to get data from that physical location, you may run afoul of some of those local jurisdictional laws. So, you know, the cloud works really well for businesses and for the way that we think about data and in the world we live in today. But from a legal litigation standpoint, the cloud can cause us all kinds of problems. Talked a little bit about this. We're going to move quickly today so we can get you to cocktails. But, you know, all kinds of legal issues dealing with the cloud, which we'll talk about. The other thing I wanted to do was just give you a little bit of a sense of why we care. What do we care about data? It's not just about the volume. There's more. Many of you may be involved in cases, and I don't know if you are, where lawyers and litigants, whether you're offshore in the UK and the US, if email is relevant, of course it's relevant, it's always relevant, but if email is relevant to the case, some lawyers will just say, well, just print the emails. Right? Sounds reasonable, sounds rational. There's a reason we don't do that as much, or hardly ever anymore in the US, and that's because of metadata. Just quick show of hands, if I can see you, how many people even know, before looking at the slides, what metadata is? All right, so a very small handful. Metadata basically is data about data. And it's the background information that computers and software store to keep track of data. So we're going to get into examples in a minute, but as a practical matter, it's all that information you'd love to have if you could have it. For example, a Microsoft Outlook email contains something like 165 categories of metadata. Everything from sent and received and who it went to the last time that email was opened, to the last time it was forwarded, to the last time it was printed. And one of the reasons we care about metadata is because we can sort and search by it, which I'll talk about, but also because of spoliation issues, which many of you know have become a big issue in the US and more internationally. And the reason it's a big issue is when you say, as a lawyer, oh, client, Brian, you're my client, just forward me all those emails and I'll print them. Well, the minute Brian forwards those emails to you, he has spoliated metadata. Because now the last time it was opened was the time Brian just opened it today. And it might have mattered when he opened it last. It might have been 3 weeks ago on the very date and time when something was alleged to have happened. The last recipient of that email is now me. So we lost that piece of metadata because it overwrites each category. And the last day it was going to be printed is going to be the day that it was either printed or sent to me. So you can actually lose metadata by doing what every lawyer in the US and globally would think is a perfectly reasonable, rational solution, which is forward me the emails and I'll print them. But there's more than meets the eye. And I like to use a Microsoft Word document as the example of what metadata can really do for us. Again, documents, we're all used to them. We pick up a piece of paper, We say, all right, here's our document. This is what we've always been dealing with. The reality is in the digital world, this piece of paper is really three different things. It's the physical paper you see. That's what we call the front of the document. It's the equivalent of a static PDF, right? It's the type of thing, if you just had a static PDF, yeah, it's in digital form, but basically all you can do is print it or look at it just like a regular piece of paper. The metadata also allows us to segregate the text, so we can do searching by text, which many of you know about. We've been doing this for probably the last 20 years in litigation. We OCR documents and then we search by text. What makes metadata really interesting is the so-called, we refer to as the back of the document. This is the hidden information that you can only see certain ways. And these are things, as I mentioned, BCCs on emails, conversation threads, but also on a Microsoft Word document, what many people don't realize is that when you are editing that document, even if you have track edits turned off, the metadata in the software are tracking everything that you do. So in a contract dispute, we can determine when a term was inserted into a document, who inserted it, when was it inserted, things that you normally would have zero access to. So metadata becomes absolutely critical if you're trying cases, and when something was done or how a document changed over time really matters and who changed it. I won't bore you with this, but this is an example once you drill down behind the document how everything looks. And we have tools obviously that get us to this point. Same thing here, just giving you a sense of once we pull the data and we really start looking at it forensically, the type of information that we get. Again, these are examples of how an email would look. It's not just the email. We have metadata on the right, which we can track. And by the way, this also allows us to do different types of searches, right? I mean, data, there's a huge amount of data we now have to deal with we didn't have before, but we have new tools to search it. Because now we can search by date range, we can search by custodian, we can search by keyword. We can search by size, we can search by attachments. We can do all kinds of things with metadata that we were unable to do back when we had those 650 or 65,000 boxes of documents, and people would just go through one at a time and look at those documents. Quick little anecdote, when I started practicing, it was, I was gonna say more than 20 years ago, around that time, everything was in paper, and when you think about the way we did document review, it was really hit or miss, right? I mean, I remember sitting in a warehouse in Houston, and at that time, it just seemed like all the documents were warehoused in Houston. And you'd go into this warehouse, and there would be, for those of you who remember Raiders of the Lost Ark and that last scene with the giant army storage space, it would look like that, and you'd sit there and you'd review paper documents. And I sat next to a woman from a different firm who was a co-defendant for 3 days, looking at documents. And on the third day, she turned to me and said, "Do you know what we're looking for?" And I sort of, and I just sort of laughed and thought, I guess she's reviewed her documents. It's no wonder American lawyers get a bad name. But now we don't have to do that anymore because we can search electronically, and metadata allows us to do that. But I alluded to something earlier which really makes a bit of a difference, and that is the volume of information we're dealing with. Even if we can search and we can sort and we can break things down by date range and we can look at different custodians and we can try to cut it and cut it and cut it. Well, if you're starting with a terabyte or two of data, no matter how much you cut it, you're still going to end up with a really big number of information, big number of a large amount of data that results in millions and millions of documents, hard documents. And so, in the US, we thought we had a handle on this. We used to use large teams of law firms and big firms until clients said, "Why am I paying you hundreds of dollars an hour to look at documents? Anybody can do that." And then we started using contract lawyers, and we paid them less, and we charged the client less for that review. And then we started sending that document review offshore, as many of you know, to places like India and the Philippines, where it could get even cheaper. And there's been a sea change in the last few years through what we call technology-assisted review. And this is where the UK is going to come in now too. Technology-assisted review, TAR, sometimes called CAR, computer-assisted review, is simply a method of review that, for the most part, takes the human beings out of it, takes the lawyers out of it. And I'm going to explain it. There are still, obviously, inputs by human beings, by lawyers, but computer-assisted review, TAR, and predictive coding, and by the way, predictive coding is simply a subset of computer-assisted review, but the most common one, are ways to review documents without having to look at every single document, and ways in which we've been cutting down the cost of doing this. And from my perspective, what's coming to the offshore world, what's coming to the UK, is going to be some variant of computer-assisted review, predictive coding. Because let's face it, I know the distinctions because I practice in both jurisdictions, at least I'm involved in both, between US discovery and UK-style disclosure. But even if you look at disclosure as a very narrow category of what we might be entitled to receive in the US, the numbers are still getting bigger. Because again, when you start with such huge amounts of data, as you cut it down, even through the disclosure process, what maybe used to be a couple of boxes of documents might be thousands of boxes today. So there has to be some way to deal with it, and not surprisingly, the Commonwealth jurisdictions have not been quick to adopt the US approach, which is have human being eyeball every single document for costs of millions and millions and millions of documents and months, if not years of review time. But computer-assisted review, I would submit, is going to allow the rest of the world to catch up to the US in terms of the types of discovery that all those jurisdictions are able to do at a cost point and a timeline that makes more sense for those legal systems. So let's get into it. All predictive coding is a computerized system. It's built upon predictive analytics. For those of you in the math world or in the hedge fund world who have dealt with the math world, predictive analytics is used across every industry that exists now, including financial services. It's essentially a very sophisticated regression analysis. And it's currently used all over the place. And I'm just going to put there, this is from the US standpoint, that a tipping point for cost is roughly 100,000 documents. That's on the low side, but the price points are getting lower and lower. So the cost of doing this in terms of the number of documents is lower and lower. So that 100,000 will only come down. And what's nice about this is once you put these processes in place, regardless of how many, it scales. So you might start with 100,000 documents, the case might get bigger, and now you have 1 million documents, but you have a system in place where you can actually do discovery on that broader, bigger data set. So it uses a mix of people and technology. And we do this a bunch of different ways, but primarily we start with a seed set. I'll say random, it's not really random, but I'll just use the word random to make it simple. We basically start with a random set of information. If we have a terabyte of information, we take a small random subset and we give it to a human being. We take, say, 5,000 documents. And we have that human being essentially make binary decisions about those documents. Yes, no. Relevant, not relevant. Or whatever flag we're looking for. Privileged, not privileged. And the system, over time, you're building this seed set. And what happens is the computer takes those 5,000 documents and the decisions that a human being has made and goes and applies what the computer thinks it has figured out through regression analysis against the broader data set. And it pulls back 5,000 more documents. And these are the documents that the computer thinks, based on that first review, should be relevant, should be yeses. And the human being again reviews. This is the second iteration. And this process continues for 2 or 3 iterations to the point where the computer refines its analysis each time until we get to about a 95% success rate, which is much better than most human beings ever achieve in review. Hence my colleague who's sitting next to me saying, do you know what we're looking for? The computer does know what it's looking for. So human beings don't get to that high of a success rate, the computer can. And the result is maybe we've reviewed 15 or 20,000 documents. Maybe we've done 3 or 4 iterations to get to that point. But once we've hit that point, the computer can then apply that reasoning and that logic to a large group of documents. It's basically limitless. It can be 1 million, it can be 10 million documents. So you don't have to review those 1 million or 10 million documents. You only had to review the 15 or 20,000. The critical piece here is, unlike my colleague sitting next to me who has no idea what she's doing, the initial review has to be done very, very well. This is the garbage in, garbage out analysis, right? You've got to get it right. If you don't get it right on the front end, you're just going to get garbage later. So the initial review is typically done by more seasoned lawyers, by people who are usually more senior associates or even partners who really have a handle on what's important and not. But once those decisions are made, it becomes a very streamlined process. And this is the iterative process I discussed. Same idea, you start with a seed set and you work your way down. Again, huge amounts of savings. This is an example, by the way, that's up on the screen now from an actual case that we had. Started with 1 million documents and we ended up here. And we ended up saving huge amounts of time, over 16,000 hours of review time for the client on that one. If you think about average billing rates being, a few $100s for somebody to review documents, it's big savings. Also, there are those who argue, and it's not even an argument, it's been established through a lot of academic journals now, that keyword searching, what we're used to doing in the past with keywords, is actually a lot less likely to get you to the correct documents than is predictive coding. Here's a typical keyword search diagram where you've got relevant documents, non-relevant documents, privileged documents. It's all over the map, right? And you can see the little circle in the middle is where you want to be. Not privileged, relevant in the middle. Compare that to predictive coding, and this is what the predictive coding results tend to look like. Much closer. Now, the privilege piece of this is difficult because at the outset, the computer's not looking for privileged documents, just trying to find relevant documents. But you can then go back and train it to look for the privileged material. So huge savings. And by the way, that's just what a typical predictive coding screen looks like when you're using the system and trying to figure it out. So in the US, this technology was new. It was never endorsed by a court until about 4 years ago when Judge Peck, Andrew Peck, who's a magistrate judge in the Southern District of New York, decided that he was going to write a decision that validates predictive coding. And he did exactly that. And he made it very clear this is what he was doing. I know Judge Peck quite well. I've spoken with him many times. He's a passionate believer in predictive coding. And although I wouldn't want him here listening when I said this because he might lose his humbleness a tad, but he really did change the landscape when it came to US-style discovery and predictive coding. Because after the De Silva-Moore decision in 2012, the rate of predictive coding in the United States exploded. And courts now not only routinely allow it, a lot of them proactively ask the litigants for them. For those of you who know in the US and federal district courts, you have to have a conference at the beginning of a case, and one of the things most judges will now ask you is predictive coding or computer-assisted review an appropriate way to look at documents in this case. So this has become a huge issue in the US, and it's really beginning to supplant sending document review to offshore locations like India and the Philippines. It's really begun to supplant using contract lawyers onshore and law firm associates to review documents. It is the future. It's been the future for some time, but it's becoming more so. And I'm not going to go through all of the decisions, but you'll see them in the materials. It's now pretty well accepted in the US. This is an appropriate way to handle discovery. What's a little bit different is a lot of these issues, the no guinea pig, the work smarter, go faster, these are lessons that have been learned along the way. And as a practical matter, we now have a pretty good handle on predictive coding and know when our adversary on the other side of a case looks to say we don't want to use it for these reasons, we know how to address those concerns. And those are in the materials. Why does this matter? Why am I here? Why are we talking about this? Well, many of you heard about the Pyrrho Investments limited decision, and this was a decision out of the UK which, at least in the US, had a few shockwaves. We never think of the UK as endorsing sort of what we would consider American-style litigation tactics. And yet here we have a case holding, and it sounds in typical English fashion, right? It sounds like it's no big deal, that nothing in the rules or practice directions prohibits predictive coding. But many take that as being an absolute endorsement of the technology. And the decision, I'd encourage you to read it, cites the accuracy and comprehensiveness of the results, and it found that a full manual review of the over 3 million documents would be unreasonable. Now, in the US, that was not really considered unreasonable. 3 million documents was a regular-sized data set. Obviously, in the UK, when you think about disclosure rules, that seemed unreasonable. And what I just found interesting in this case is that the court could have just said, it's too much. But instead, it essentially validated the use of predictive coding to review those 3 million documents. So do we see that sea change? We go from a system where review of 3 million documents would for the most part be considered unreasonable to a system where that becomes reasonable because of the technology we now have at our disposal. So big changes in my view in the UK, and we all know that changes in the UK are going to result eventually in changes to the offshore jurisdictions because they're following their lead. And while the decision may be of limited precedential value, it's the first one we know of issued by a UK court to say that predictive coding is reasonable and can be used. So that is my quick primer on predictive coding. What does it mean? What does it mean for the US? What does it mean for offshore entities? And so I'm going to turn to Matt for a minute because I think there are two issues where this plays with the offshore world. One is, when can offshore corporations and funds be pulled into US-style discovery and litigation? And the other is, if you have an offshore entity, you may want to use, as many of you have done in the past that I've worked with you may want to use US-style discovery tools in cases that maybe aren't pending in the United States. So Matt, can you walk us through those two options?
Sure. So most of you are probably familiar with the Hague Conventions on Service and Evidence. Those were the traditional means by which US litigants, whether it's the SEC in an enforcement action or private parties, can obtain discovery from offshore entities. And when I say discovery, I don't mean what US lawyers generally think of as discovery, the pre-trial sort of open up everything. Most signatories to the Convention on Evidence limit the amount of evidence that can be obtained through the Hague process. So while it's used here, it's of limited value. You can generally get a witness, essentially a witness testimony before a foreign court, but you can't get the expansive deposition testimony that you would be afforded in the United States. You can get some documents that you are likely to use as exhibits in your trial, but you can't go on the sort of fishing expeditions that US courts routinely sanction the parties to conduct here. So the Hague Convention has been of limited value, and we have seen in the last few years increasing efforts by not only private litigants, but also the SEC in particular, to try to circumvent the Hague Convention to obtain what is more akin to what we're likely to get in US litigation. So the example that comes to mind from the SEC standpoint was the Chinese accounting fraud cases from a couple of years ago. Several companies, as you may recall, including Longtop Technology Services, which was a Cayman company that operated primarily out of China, they were investigated by the SEC because their shares were listed on the New York Stock Exchange. The SEC sought the working papers from the Big Four accounting firms, China Arms, which were separate entities based in China, and they were subpoenaed by the SEC, and the subpoenas sought sort of the big data that John was talking about before. They were looking not just for the traditional documents you might be able to obtain through the Hague Convention, they were seeking a substantial amount of metadata, electronic documents from the Big Four accounting arms. The Big Four, the attorneys for the Big Four accounting arms objected based on China's secrecy laws as well as jurisdictional challenges, and the SEC took it to a federal court in Washington to try to force compliance. Now the parties were able to work this out through settlement and negotiations with the China CRSC, but it, I think, stands to suggest that the SEC is taking a much more aggressive approach when they are looking for documents and evidence from offshore entities. And we're seeing the same thing from private litigants. We are seeing offshore entities that have any sort of touch in the United States are finding themselves potentially subject to attempts by private litigants to obtain discovery. If an offshore entity has a limited partner or an officer that happens to be located in the United States, we have seen efforts to serve a subpoena looking for the documents of that offshore entity through the onshore person or entity that's here. The argument being that we're no longer talking about documents in a warehouse in some offshore land that the court can't force a party to produce. We're talking about documents that are on the cloud that ostensibly an officer located in the United States can access with a login and password from anywhere. And so the argument that traditionally was made to courts that these are issues that are best dealt with in the foreign jurisdiction, these are documents that are located over there, those are harder and harder to make given the technology that we're encountering. So, and I think it's only going to increase that parties and regulators are going to be expecting the sorts of documents that John's talking about in connection with their investigations and litigation.
Yeah, Matt, I was going to say, before we get to 1782, Matt and I are involved in a case that involves an Asian fund that was invested into the U.S. And the U.S. fund had issues, shall we say, and there was some fraudulent activity. So the client in this case is a limited partner offshore, did nothing wrong. In fact, they were a victim. They were an investor in a fund that was victimized by the general manager, general partner of the fund. Yet, once we get into litigation, we got into some issues, it became clear that our client, the offshore entity, was going to become a target of information requests, and not just from private litigants after the fact, but even from the SEC. And it almost, we live in a world now where I think parties just don't expect you to raise these barriers. That, oh, those documents are in Hong Kong, or they're in Kuala Lumpur, or they're in Singapore. The SEC called me up and just assumed that I would accept service of a subpoena and comply with it for the client, or that we would simply voluntarily produce documents, completely unaware that in the host jurisdiction, you can't just go dig up documents and ship them to the United States and give them to a regulatory body. It doesn't work that way. Similarly, in the follow-on civil cases, parties would make the argument, and there were other offshore LPs, that discovery against the fund is not enough. That what we really need is discovery directly against the LPs, because once the information was passed to the LPs, we want to know what they did with it. Did they rely upon it? Did they use it in some way? You can only get that through the LP investors who are offshore. And to make it more tricky, obviously, and many of you deal with this, whether it's in most of your offshore jurisdictions, people, even who really do live in the offshore jurisdictions, they traverse through the United States. So it gets to the point where, okay, if I'm coming in from Singapore and I'm going to a conference in San Francisco, and I bring my laptop with me because that's what normal business people do when they travel, and now that I have my laptop, I could use that laptop either to access documents directly from the hard drive or to log into a remote server and access documents that are in Singapore. Can I be served with a subpoena as a citizen of Singapore who has no connection with the U.S. other than I showed up at a conference in San Francisco? And the answer is becoming more and more, it looks like people are trying to do that, and we're seeing some interesting decisions. And we see it not just on the regulatory side or the criminal side with the SEC, but we see it with private litigants as well. And the private litigants' response is, if you don't produce the documents, well, then I guess the case should be dismissed because, the parties aren't cooperating in discovery, to which we say, wait, the LPs aren't parties, the fund is the party. But those are the types of arguments you run into. And the problem is that once you begin down this path of producing documents, as Matt's talking about, you then end up with the electronic data requirements that we've discussed. Because these documents are going to be produced as part of a U.S. litigation where the U.S. rules of procedure apply. And those rules require you to produce data and emails and to do all the types of data mining and searching and collection and production that we're used to in the U.S., but maybe a party in Singapore is not. So Matt, that's sort of the offshore piece. What about offshore clients and entities that want to obtain discovery in the U.S.? We represent lots of liquidators and others offshore who just salivate at the notion that they can get this type of information because you can't get it in your home jurisdictions. Do they have any recourse?
Well, right, the good news is that everybody here can play our pre-discovery game. So there's a U.S. statute that has largely replaced the Hague Convention on Evidence for purposes of U.S.-based discovery, and that's 28 U.S.C. 1782. That is a statute that allows parties that are involved in a foreign proceeding to obtain discovery that is located in the United States from a party that's located in the United States to aid in that foreign proceeding. And there is a specific way that you go into a federal court in the United States where, for example, if you are a offshore liquidator in a liquidation proceeding in BVI and want to obtain documents from a entity, say a accounting firm that's located in the United States or that that was conducting an audit in another offshore jurisdiction but has a presence in the United States, you can go into a federal court and ask the federal court to order that third party that's based in the United States to respond to a subpoena that you issue to assist in that foreign litigation. And there are certain standards that have to be met, but it's it's one that we have done a number of times successfully, and courts are amenable to this procedure. The statute is very clear what you can obtain, and once you get a court to sign off on the subpoena, you are now within the realm of U.S. discovery, which is a very expansive, as John explained, notion of what you're entitled to get. And once you have that subpoena authority, all bets are off. You can ask for the metadata, the predictive coding sorts of analysis, depending on the size of the case, and assist you in a way that you were never previously able to get these documents to help in the foreign proceeding. So it can be an extremely valuable tool for offshore entities looking for evidence that they might not otherwise be able to obtain.
Yeah, we have used this an awful, and many of you know about this procedure, I know, because you've hired us to do it. But that being said, some still don't, and I think what a lot of folks forget is it is the full, as Matt says, the full panoply of discovery tools are at our disposal, including depositions, including review of millions and millions and millions of documents. The federal rules of civil procedure in the U.S. changed again just a few months ago, and the new changes have a requirement that discovery be proportional to the needs of the case. And you may have heard a lot about that in the press. What makes some of the actions, though, that originate offshore is they tend to be fairly large, right? If we're talking about a fund meltdown or litigation, we're talking about hundreds of millions or billions of dollars in lots of cases. So it's very easy to make the argument that critical material that's sitting in the United States is not only relevant, but proportional, because so much is at stake. And as a result, I think we're going to see more use of 1782. The other thing I'll just say about 1782 before we move on is some of you are also familiar with Chapter 15 of the U.S. Bankruptcy Code, which allows some of the same types of procedures and some pre-litigation discovery. The difference here is that Section 1782 is much more of a rifle shot. It doesn't take the same amount of resources, effort, time, and energy to file a 1782 petition than it does to establish a Chapter 15 proceeding. And there's less of a chance that there are going to be other jurisdictional issues that attach. When you file a Chapter 15 bankruptcy proceeding, the entity is suddenly in the U.S. for purposes of that proceeding. This is different. This is one way. It's only offense. It's I filed my petition, I either get my material or I don't get my material. There's nothing the other side can really do to make your life all that miserable. So it's a really important tool. We've talked about it at this conference in years past, but I think coupled with the explosion of predictive coding and the quasi-endorsement of predictive coding by a Commonwealth jurisdiction in the UK might make this an even more important tool going forward. So we're going to turn to criminal and regulatory investigations, and there's a lot of slides, and they're there purposely so you folks would have them in your materials, but we're not going to go through all these slides. What I want to do instead is turn to Brian and get a sense from him from the government standpoint. And by the government, I mean the United States government, the Department of Justice, the civil and criminal regulatory authorities like the SEC. What are they doing to chase not only documents and data, but people and assets in offshore jurisdictions? And to what extent are lawyers putting up blocks to those types of activities, and how is it playing out?
Thanks, John. And just to be clear, you've referenced now a couple of times the colleague to your left who doesn't know what's going on, just so it's clear it's not me.
Over there. He's over there.
Right, that's right. Yeah.
far
Well,
left?
you know, I think both the U.S. Attorney's Office in the various jurisdictions, as well as the SEC, are being increasingly aggressive in trying to use these same tools against their targets. And I think whether it's through a grand jury subpoena or an SEC request, we're going to continue to see the government trying to obtain this data because, from their perspective, it's the best way to build a case. They always joke about how in the word email, E is for evidence, because that's how they gather witnesses. If they can get an email or some sort of data that is in the USA, they can make a case, notwithstanding the target may be offshore. John referenced the Bulger case at the outset, and while that involved a lot of murder and mayhem and racketeering charges, it also involved money laundering charges, which are fairly simple charges to bring as long as there are some sort of financial transactions here in the U.S. And I think that's going to become an increasingly powerful tool by the federal government in their efforts to battle what they perceive as the problem of big frauds. So I think that's one thing that I'm seeing more of, and I think in our role we often push back on it, but you know, the grand jury is a very powerful tool and you don't have a lot of access to what's going on there.
Can you explain a little bit, Brian, when you say you know, that they're using the U.S. system? What do you mean by that, and what types of activities would count?
In simple terms, money laundering here is fairly simple a charge to make. All you need is a transaction, a deposit, a transfer, a purchase. That is a financial transaction for purpose of the money laundering statutes. If the transaction is based upon monies that are dirty, in other words, they are a specified unlawful activity, which can be many different things. If the specified unlawful activity occurred offshore, it doesn't matter. If the financial transaction occurred here and it was using money that was the product of, say, a fraud offshore, that is sufficient for the federal authorities here to bring money laundering charges. Now, and if they seek an indictment and they get warrants, the person may never know there is a warrant until he or she travels into the U.S. and the warrant hits and the person is detained. But you know, money laundering sounds complicated. It really isn't. Any of these seemingly innocuous financial transactions using the banks can be the basis for a money laundering charge if, in fact, there's an underlying what they call SUA. And the specified unlawful activity can be a whole host of crimes. The most relevant ones here are fraud, like bank fraud type charges.
So let's spin it out for a minute. If I only wish I could be a hedge fund manager in Cayman, wouldn't be doing this anymore. If I'm a hedge fund manager in Cayman and I have an account at Morgan Stanley where I park cash as some liquidity opens up, and then I move it around the world once I know where I want to invest it, and I'm subject to some SUA. And let's say, for example, the feds are able to get a warrant, which I know nothing about, and now I want to travel from Cayman or BVI back to London, and I make the mistake of making a connection in San Juan or Miami. Can I be arrested?
Oh yes, oh yes. I mean, the easiest way to understand it is a lot of these Colombian cartels, they obviously have an FCPA. They have massive drug dealing that's occurring. It's easily proven. And what happens is, if they use the financial system here in the U.S., part of the charges that ultimately get lodged against them are money laundering charges. And if the grand jury, which meets in secret, returns an indictment, that's always sealed until the arrests are made. So if you're standing alone, you're charged with all sorts of crimes, you're never going to know until you travel through the U.S. And if they've got the arrest warrant, they'll have what's called a detainer on you, and when you go through the airport, you won't be going back to the gift shop, John.
When they scan my passport, I'm going to be brought into that little side room? Is that what's going to happen?
Something like that,
Something
right?
like that.
Yeah.
And Brian, just so we're there, I mean, I used the example of a hedge fund manager, but I mean, theoretically, this could apply to anybody who's resident offshore, but who's coming to the U.S. I could be an independent director of a fund, or I could be, I could really be anybody. I could be an accounting professional. If I'm alleged to have committed some type of crime or conspiracy, that would apply.
Yes, and bear in mind, I mean, the government has limited resources, believe it or not, so they're not going to go after every garden variety fraud offshore, but if it's something that's come to their attention through a variety of sources, whether it's a cooperating witness or whether it's in the press, and they want to target it, then yes, even the fact that you're living and working offshore, if you travel into the United States and you've had some financial transactions here, if it's the product of an SUA, a specified unlawful activity, that subjects you to criminal charges here.
And Brian, how would the feds get, I mean, we talked about some of the discovery techniques, but presume for a minute that the data is sitting in Cayman. How do the feds get access to that information? Is it here in the U.S. as well? Can they go to Cayman and get it? How
Sometimes
do they do that?
they work with the foreign authorities to gather evidence. They work a lot with UK authorities. So it's a burdensome process, so they don't like to do it. They vastly prefer just to use the subpoena process here in the U.S. with the grand jury, where all the banks have to comply. And of course, you never know where all these emails go. So if you're the third person on the email list, and you've got the hot potato, they can get it that way.
Right. So it may be that the email was sent to, it may be a long chain, but it was sent to a banker in New York, and now it's sitting on somebody's server in New York City.
And now the bankers in the grand jury being questioned about that email, explaining who this person is, who that person is, and what's the basis for this transaction, that sort of thing. That's how they build their case. It's like putting a puzzle together. A grand jury meets in secret once a week. It's unlike a trial jury. So the grand jury hears evidence over the course of 18 months. And after 18 months, the prosecutor can recommend that the grand jury file a charge, which the prosecutor prepares in advance, and the grand jury votes upon it. And over those 18 months, all sorts of evidence is presented to the grand jury. There's no defense lawyers in there in the federal system, so it's just the prosecutor once a week presenting this piece of evidence, that piece of evidence. Some of the evidence is in the form of witness testimony, and people can be compelled to testify. Everyone in the U.S. has the right against testifying based upon the Fifth Amendment privilege, but oftentimes in a fraud case, they will immunize witnesses. And we did that a lot, again, in a different context, in the Bulger prosecution, because a lot of the people were unwilling to testify. They were afraid to testify. But once the court issues an immunity order, that supplants the Fifth Amendment privilege, and a person either has to testify or go to jail for contempt. And sometimes the people would go to jail for contempt if they were so afraid of the people they were protecting. But typically in a financial crime scenario, once a witness is told you have immunity, they will testify. They will not defy the court order and thereby risk jail. So over the course of these 18 months, the prosecutors have many tools to make a case. And at the end of it, it doesn't have to be 18 months, it can be 12 months or 15 months, what have you. But then the grand jury returns an indictment. And once the indictment is returned, the federal magistrate issues an arrest warrant, and that gets lodged into the system. So it's all over the country, anywhere you go.
And Brian, you talked a lot about the criminal prosecutions. I assume we're talking about the Department of Justice and the rest. But how does the process differ if it does with the SEC?
Yes, the SEC has much less power to compel your testimony. They can ask you to come in. You can refuse to give a statement, and while that is in a civil context deemed to be give rise to an adverse inference against you, you can't be held in contempt or anything like that. So typically, in my practice, if I have somebody who's being investigated by both the SEC and the U.S. Attorney's Office, you're most worried about the U.S. Attorney's Office because they can put you in jail. The SEC can bring you in, you can refuse to testify to them, and then they can use it later if they bring charges as an adverse inference. It's not proof of guilt. The U.S. Attorney's Office can't use it at all. The fact that a person invoked his Fifth Amendment privilege can't be used. But the SEC still has broad powers in the financial world to create havoc for the recipients of their subpoenas. They just can't enforce it criminally.
Right. Matt, let me go back to you for 1 minute, because Brian was talking a little bit about, at least in terms of issuing arrest warrants and other things, if money goes through the New York banking system or if there's an account in the U.S. We see this in the civil side a lot too, in terms of, and we've counseled many offshore clients about this, is there, if the U.S. is viewed as a favorable litigation destination, for example, for a plaintiff, maybe it's a liquidator who's taken over a fund, maybe it's a third party, finding a way to litigate in the U.S. often becomes the issue. And one of the things I know we've talked about a lot is have you utilized the banking system to the extent that it would subject you to jurisdiction? How does that compare with what Brian's been talking about on the criminal side?
Well, it's your entree in. If you can establish jurisdiction, and most judges in the United States, believe it or not, don't want to hear that they don't have the authority to hear a dispute. So if, getting into the court, getting before a court is half the battle, and, judges in most jurisdictions will accept jurisdiction as long as there's, sufficient nexus to some U.S.-based activity, and it doesn't have to be a lot, particularly if the activity is directly related to the transaction at issue in the litigation. So, merely having a financial institution in New York where you're doing the banking that resulted from the transaction that is the subject of the lawsuit is generally deemed sufficient to have the New York court hear the dispute. And once you're in, sometimes our offshore clients have a hard time understanding that once you're established in a U.S. jurisdiction and you are able to take advantage of the broad liberal discovery that is available to you and available to use against the other side, that oftentimes drives the settlement negotiations of the case. I mean, the costs, while there are ways that we're trying to curtail them, the discovery costs in U.S. litigation are always the most expansive amount of cost that the litigation incurs. So the threat of U.S. litigation or the U.S. discovery costs against a defendant really drives settlement in many cases.
Right, and we haven't talked about it today. This has been a discovery-focused presentation, but also when we think about U.S. litigation, there are other components that make it a good forum, not just for plaintiffs, but also for settlement, such as, the American rule on legal fees. Everybody covers their own legal fees. Losing party does not pay the other side's legal fees. The pleadings burden in terms of notice pleading, where, I can say upon information and belief and then make up some wild story, which we're not able to do in Commonwealth jurisdictions many times. So there are those benefits. So, Brian, I'm going to turn it back to you and just talk about a couple of specific statutes which I know interest this group, one of which is the FCPA, the Foreign Corrupt Practices Act. How does that, it always still amazes me how it is that the United States government brings these types of claims. And I'll start with, I think the way the government gets to this point is because of the data tools we've talked about. They now have access to information they never had access to before. So maybe it's easier to find the information. But then once they have it and they want to bring an FCPA investigation or a prosecution, how do they proceed?
Well, typically, a lot of times in the media within the country that reports some sort of corrupt activities, it trickles back to DOJ. And the Department of Justice has added a lot of resources to these type of investigations, as has the FBI. And they see it, I think, in some ways, as a financially lucrative little niche that they bring these cases against large companies who invariably settle at high amounts. And, again, you need an American-based company of some sort, and you need some sort of corrupt activity overseas involving a state official. But the problem is, from these companies' perspective, it's not always clear who is a government official. In some of these countries, there are all sorts of people who can be deemed to be public officials. So if those public officials are receiving something of value that is of more than de minimis value, that can create problems for these companies. And invariably, all these major companies have all these internal investigations going on, trying to determine whether or not certain things warrant self-disclosure to the government, because the government suggests to the corporate world that all you have to do is self-report and things will be much, much better. I think there's been a change in thinking about whether that is accurate, because I think some companies have found that by self-reporting, they have ended up incurring huge fees on investigations that ultimately go nowhere, but still they've had to defend it for years. So the government makes those cases the way they make other cases. You know, they still need witnesses, they still need evidence, and one of the ways they get evidence is through the subpoena power. They work with foreign authorities, and no doubt data is a major element of the cases that they make.
And, you know, we saw in an earlier panel that was being discussed about how some companies are trying to shield, especially in China, operating companies from the influence of the home government. So you see structures where you might have a Delaware LLC, you might have a subsidiary corporation set up in BVI, you might have a subsidiary to that set up in Hong Kong, and then that Hong Kong entity may own the actual operating company in China. But that structure seems to me, Brian, because it starts with a US-based company in Delaware. That could be the US hook?
That can be the hook, and they can put in witnesses from Delaware, and they can peel back the onion, so to speak, to determine, you know, to trace it just like that, so that if there are corrupt activities in a foreign country involving foreign officials, it can't be a private matter, it has to involve foreign officials, then that company back here in the U.S. Can be held liable. So
the sort of lesson is by alleviating one evil, you might be buying a whole different set of problems.
That's right.
Okay. Let me ask before we move on. I know I've got, they moved cocktails to 6, and I would never dream of holding you anywhere near past 6. In fact, I tend to finish a little bit early so you can get there right at 6. But before we move on to a couple of final points, are there questions? Do people have comments or questions they want to make? And I'll try to look here. There's one over there, I think. I thought I saw a hand. Yep.
If the financial transaction is here with a U.S. banking system, then yes. But remember, there still has to be an underlying SUA. There has to be underlying fraudulent activity or drug dealing activity, that sort of thing. But the short answer is yes.
But I think so. But Brian, just so we're clear, and I don't know if I don't know the answer, but if I'm a Russian company and I did some deal with a Chinese company, but we denominated the transaction in U.S. dollars, even if we didn't use an intermediary bank in the U.S., can we? Is the dollar transaction enough, or is that?
Oh, I don't think that's right. I think the actual transaction has to be here.
It has to come through the banking system.
Yes.
Okay. Other questions? I thought I saw another hand somewhere. All right, we'll plow ahead. So just some tips which we wanted to cover. First of all, a lot of these data issues revolve around or start with data retention policies. And you know, this has become a very sophisticated tool in the United States, a little bit less so in other jurisdictions, but I kind of think now of data retention policies as being a misnomer, because typically data exists in so many places that I don't care what the retention policy is, it still is there somewhere. You can hit delete as many times as you want. People have data on laptops, they have data on hard drives, they have data on thumb drives, they have data in the cloud, they have it on their phone. It's rare that a piece of data is, it's on backup tapes, it's rare that a piece of data is completely eradicated ever. But keep in mind that depending on the retention policy, whether it's a company or an operating fund, will determine what's available later. Understand that, at least in the US, we're talking about, you know, in really short timelines in terms of production, which might drive some of the use of these alternative technologies. You want to consider computer-assisted review, technology-assisted review, if you are an offshore entity and you are litigating in the United States, or if you're filing a petition for discovery in the United States, as Matt was discussing. You really want to think smartly about what's the best and most efficient way for me to get what I want. Do I really need 2 terabytes of data, or am I really looking for something very specific and short? Also understand that, you know, there are data privacy issues, which I know a lot of people in this room are very familiar with, that are very different in the EU and in Asia than they are in the US. I mean, typically in the US, the prevailing assumption is, if you're dealing with a corporate server, that the data on that server, even if it's personal information, belongs to the corporation. The email, my email as an employee, belongs to the corporation. That presumption is flipped in many jurisdictions, which assume that the data is owned by the individual or is controlled by the individual. So we've had these situations arise, which is something to think about. We see it a lot in the pharmaceutical area, but we also see it more and more in the financial services area now. You may have, a German or a Swiss parent of a U.S. company. That U.S. company gets embroiled in litigation, and a U.S. judge, not surprisingly, tells the U.S. company it has to produce certain information in discovery. That information only exists on a server in Germany. This happens to us many times. You call up the company in Germany, you say, we need this information. They say, no can do, not going to happen, can't do it. You get German counsel involved. German counsel tells you that it would be a criminal violation to take data off the server in Germany and ship it to the United States, even for use in the litigation. You go back to the U.S. judge and say, gee, judge, I'm sorry, we tried. We can't produce this information because they're going to throw people in jail in Germany if we do this. To which the U.S. judge replies, I don't care. That's not my problem. This case is before me. The federal rules of civil procedure apply. This data is relevant. You either produce it or there's a default judgment going to be entered against you. And so it puts companies in the impossible situation of either being defaulted in the United States or committing a criminal violation somewhere else in order to comply with the discovery rules. So one way to think about this, and the same is true in financial services, and the same can be true in offshore jurisdictions. One way to safeguard that is to have your data housed in places where it might be easier to access. We did this in some cases. We'll have a parallel server in the U.S. so that if we're in litigation, we don't have to go to a foreign country to get that type of data. So it really does make a big difference where the data is housed. Less so with the cloud now, but even so, there are physical servers in places. We're going to skip search warrants. Parallel proceedings, Brian touched on this. I just want to touch on this briefly, and Matt, I'll ask you about this too. And that is, we see this many times. Let's take the criminal element necessarily out of it, but we're involved in many cases where you have the SEC running a matter or investigation at the same time that private parties are conducting civil litigation. And this does involve the fund world a lot, and does involve Cayman and BVI entities that we've been involved in litigation with. So Matt and then Brian, I guess, how do you handle situations where you've got a regulatory authority like the SEC trying to run an investigation or try a case, and you've got private litigants that are trying to do the same thing?
Well, unlike in the criminal context there, they proceed in the civil context on parallel tracks. So, in courts are generally, assuming they're even in the same court, not deferential to the SEC versus a private securities litigation case, for example. So, timing though becomes important, especially depending on who you represent in that case. We've had examples where we have represented investors who have sought recovery from funds that the SEC has also sought recovery from those funds, and there's only one pot of money at the end of the day, and whoever can get the judgment to get that money first is going to get it, and it becomes a matter of pressing forward faster than the SEC in that instance, and hoping that you can get the witness or the defendants to provide testimony in your case that they may be unwilling to provide in the SEC case, given the much more severe consequences that could result from an SEC finding of liability than they would from a private litigant where you're just talking about money damages. With the SEC, you're talking about potential lifetime bans from practicing before the SEC in the United States. So the timing is important, and the parallel tracks can be used to your advantage.
And to flip it, Brian, what if you're representing an entity that's being investigated or tried by the SEC and you've got ongoing civil cases?
Well, I think typically the bigger concern that we have, and one I've had recently, is with a U.S.-based fund where there was some fraudulent activity perpetrated on the fund, and the SEC came in real strong initially, but that was soon followed on the heels by the U.S. Attorney's Office with a criminal investigation. So what happens oftentimes is then the SEC stands down, and the U.S. Attorney's Office or the Department of Justice will handle it criminally first. And so then the focus becomes making sure you don't get entangled in the criminal investigation rather than the SEC's civil investigation.
Right, and so I would say, we've been on both sides of the V in civil cases where the SEC has gotten involved, and I'll just put this out there. You never know how a case will go, but a lot of clients think that the SEC getting involved is a good thing. And the reality is sometimes it can be good and sometimes it can be not so good because you lose control of the process, number one. And number two, we've had situations where the SEC comes in, beats you to the punch, gets a consent judgment or consent order, and now there's a $500 million judgment essentially against the fund or the individual and can ruin the amount of effort and work you put into getting to your civil judgment because you're going to sit behind the SEC. So something to think about, and that's why good pre-investigation, good data discovery is important. I'm going to ask one last call for questions if there are any, or if everyone's really thirsty. They're really thirsty. Folks, thank you so much for your time. We appreciate it, and have fun tonight. Take care.
Thank you.
Thank you.